morning, Your Honor. Teresa Holzer, bar number 11813, for the defendant, Rebecca Whitmore, who's also present.
The plaintiff. You know what? I don't know why we had. Which way do we have, Madam? Yeah, we have her as, I don't know why, because she's listed, I guess, in the joint petition first, so
yes.
we have her as plaintiff now.
Right.
So from this day forward, she'll be considered plaintiff, and the defendant will be considered the defendant. Mr. Whitmore, did you get the paperwork?
Yes, I did receive the paperwork. It was 2 weeks ago when I got it.
Right.
And I just retained an attorney last night, finally, because no one else would hear me at short notice. And he isn't able to make it here today. He's in Goldfield. He said he was trying to get a conference call in, but couldn't. And he said he was going to fax over something to try and get a continuance.
So is that what you're asking for today?
Yeah, I would like a continuance, just whatever you feel necessary, just in order for me to present myself and be represented properly.
Okay.
I believe a lot of this.
So it's one of the things
false.
that I did not see in your paperwork is the new family court rule that requires a statement under EVCR 5.501 that you reached out, tried to work it out with him. Did you try to work it out prior?
Yes, I did, Your Honor, and
sorry.
that was stated in there, and I attached as an exhibit my letter
I'm sorry.
that was sent back in October to Mr. Whitmore, October 10th. It's
You are
Exhibit C.
correct.
Your Honor, we've been trying to reach Mr. Whitmore for months now. The letter was sent out to him in October. Various family members contacted him. I have had absolutely no contact from him. The motion papers were delivered priority mail. They were there in his P.O. box by Tuesday the 15th. I spoke with him yesterday for the first time in an effort to try to resolve this, and this is the first I've heard of Mr. Glennon, who I know has an office in Goldfield, and I don't know that he, I haven't been contacted by any attorney or anybody, that's representing him.
Well, here's the thing, Mr. Whitmore. Let me ask one question about, because they both, I don't know that it's a situation.
I think mediation could resolve most of these issues. I mean,
Well,
except the car. I mean, that's the big issue.
well, the other stuff is just co-parenting type of issues.
Yes.
And I don't.
So Mr. Whitmore needs to be admonished that when the mother calls the child, since they have joint physical custody and joint legal, that she has privacy to talk with her. They've been keeping her on speakerphone. They interfere with the conversation during the conversation. They removed a tracking device that they had placed on her. It's my understanding that Mr. Whitmore, has moved on with his life, as has my client, and he has a companion or a fiance, and I think, part of the time, that's part of the issue. She cannot interfere. She is not the parent with legal custody. My client is. The child cannot be left alone. The child cannot be enrolled in school without my client being listed. These are simple things.
No, I agree.
Yeah, and my
Understand
client
that?
has been delivering the child, and she can't do it anymore because she lives and works in Mesquite now. So he needs to pick up the child, or they need to meet
Well,
halfway.
if she's the one who moved, is she the one who moved from the valley?
Well, she had no choice. She had to get work.
Well, the best I could do is receiving party pickup, but I can't,
Yeah,
particularly
that's
when
fine.
she's the one who moved out of the valley. But I'm not the proposition about meeting in the middle. It just doesn't work. I mean, people run late.
We're fine with receiving party. I mean, she was agreeable at first, but then, it's become a burden for her. She's working. She tries to have more than one job, and receiving party should pick up the child.
Are you okay with that?
Your Honor, everything in there that they're stating, I have a little bit of proof that I put together because she said that they've
Listen,
been reaching out to me
ultimately, if
for
you want to
months. I haven't received anything until 2 weeks ago. I checked my mail and got that final letter because my grandma told me it was there, and I checked that day and it wasn't. That was on like the 12th. Obviously, she mailed it the 14th.
I
but
have proof that
I
it was
did
delivered
rec-
to the listed PO box that's registered with this court. I have also been contacted by numerous people. Mr. Whitmore himself says he goes to his mailbox once a month. I can't control that. He knew about this for a long time because his grandma and various other people have called me on his behalf. And he got my letter in October.
There's stuff that we can just do some admonishing today, and if it continues, then we might have to get someone involved, like a parenting coordinator. You don't want people to get involved like that. First of all, that costs money. Is it true that you list your significant other before her as the parent at the school?
No, it's not. I have a copy of that too.
Did you change it?
No, it's from the school. We just went and had them print us a copy of what we gave them before she enrolled.
Okay.
I filled it out. If
Alright.
you'd like it.
No,
Well, my client swore to the truth of everything and under the penalty of perjury.
I understand, but if you've got the document showing that that's not the
Oh,
case.
that's fine, I'd like to
Would
see
you like me
it.
to bring it up?
No, just show her.
Okay. Here's what I filled out, and she is listed as the mother. I just didn't put her contact info because she lost her phone and this and that, and I figured she would do that at the orientation that she was present at.
The
We
first
both went to a meeting.
contact info is a Lauren Kimmel with all her information.
Who was that?
That's
This-
my fiance. I just listed her because she's the one that picks up and drops off for
That's
me.
what we're
Contact.
talking about. The first should be
contact.
her.
The mother is listed with nothing,
I listed her mother, and then she
no contact at all.
put her information on there before she even enrolled in school, before she started school. Because when we met at the orientation,
She rang to the school when she heard about it or contacted
So
her.
just have your client go and change that, and if you need an order for me
I think
for her to
it's
do that.
my client knew
That's
it.
exactly what they allege, Mr. Whitmore. You're not doing very well here right now. That's exactly what they alleged.
I just filled out my part, and I assumed she would fill out her part because she didn't have.
No, I asked you. I haven't even seen the paper, but I said, who's listed as the first contact? You said her.
No, I said I listed her as her mother.
First contact is Lauren Kimmel with all contact information. Rebecca's listed second without any contact info.
I listed myself, Lauren Kimmel, and Becca Whitmore, and then my pickup people, which is my aunt and a mutual friend of ours.
I mean, they have a
Go change it.
parenting agreement.
She already revised it before school started. She put her contact info on here. She did it.
So
on
it's
here.
changed?
She also wasn't
was on
consulted
here.
before they enrolled her.
Has it changed? Has it been changed since?
Yes.
Okay.
And she went in and she changed it.
Before we get too deep into the car, and again, I'll note that he's asked for a continuance. I'll let him know that if he's not successful in it might actually end up in attorney's fees. But when was this particular car purchased? Because both of you signed paperwork saying there's no assets and debts in this marriage.
Yeah.
Both of you signed that. So when was it purchased?
It was purchased in December of 2013.
Okay, I'm not dealing with it. It's not part, it was something they had prior to the marriage.
But
I
she,
was still legally married to my
It's
first
not
wife,
part
Your
of,
Honor.
yeah, it's not part of this case, counsel. I'm not dealing with it. If it was purchased during the marriage and was a marital asset, regardless of the circumstances that he allowed her to keep it, then she can file out in justice court or wherever she needs to do. But I'm not making that part of this divorce. It's not an omitted asset because it's not a community property item.
well, they cohabited, Your Honor,
It doesn't matter. It was a separate property item he brought into the marriage.
that she was using
And
and
they
had
signed
a
a
child.
verified joint petition that says we have no assets and no debts. I'm just simply not dealing with it.
She relied on a verbal agreement. She would have asked for other sums of money to help herself.
You know what?
I
She
got that
could have
too.
included it in the written paperwork.
They had no representation, Your
I
Honor.
understand that.
She just had a baby.
It's his separate property from prior to the marriage, by her own admission. They were only married a short period of time. So more than 3 years prior to the marriage, it was his separate property.
No, they were together at the time.
Well, they weren't married.
They got divorced in 2017.
They got married in March of 2016, which means this vehicle was in existence far prior to this marriage. I'm not dealing with it. I'm not dealing with it.
Thank you, Your Honor.
He gave her the car, Your Honor. She was
I'm not
using
dealing
it.
with, you know what, that may be the case. Go file in justice court, I guess. We're past the 6 months in this case, and I'm not considering it a admitted asset, because at best, I don't even know how you make that argument in justice court.
She's paying for the insurance and the registration, and she's not allowed
This-
to make any claims for damage to the car. I mean, the
That-
parties had an agreement. Their conduct has shown their intent.
It's not a marital asset. Was
It's
not
an
purchased.
asset that he acquired before the marriage was
Exactly.
with her, and then he gave it to her and let her have it.
And you know what? That's what Judge Judy cases are all about, are gifts of things. It was not included in this divorce. It was something prior to the marriage. I'm not dealing with it at this point. It's not going to be an asset that I deal with. It's not an omitted asset per se.
Your Honor, the statute, speaks to settlement and mistake when the parties adjudicate their assets, separate community, including debt. She had a baby. She found out her husband was unfaithful to her. The marriage was over.
That has nothing to do with anything,
She had to leave,
counsel.
and he let her have the car.
That has anything to do
They
with
could have agreed to that car in writing, but she relied on his verbal
I'll
representation.
read right from the statute, 125, 130, subsection 3. Any community property or liability omitted. You're trying to say, I'm sure he's going to deny there was an agreement. Again, at best, you have some sort of gift situation. That is not community property. It's simply not.
Well, it's in the interest of justice. It's a point of settlement for them.
Yeah, I'm not saying they don't have a right to make a claim against it. They can file in justice court is where they can file, because I'm assuming this doesn't exceed $15,000. But it's not my issue. And I'm not going to take it up because, again, it preceded this case. It is not a community property or liability. It wasn't.
But it was during the course of their relationship and their marriage, and he let her have it, and she needed the car, and he gave it
That
to her.
is-
They would have negotiated differently. She was not represented by an attorney, neither was he. She was completely relying
Right.
on his word.
I'm simply not taking it up in this case, counsel. I don't say she doesn't have
All
a
right.
case. I'm just simply not taking
I
jurisdiction.
appreciate
over
what
it.
you're saying, Your Honor.
I'm not
but
taking-
community assets can, separate property
It's
can
not
become-
community assets even under your own designation. You're trying to say that it got transmuted in some way
Yes.
to that. It doesn't, we're not talking about transmutation or anything in that. It's not community property per se. I'm guessing you're denying that you had some sort of agreement with her?
No, we had an agreement, but it's not what they're saying.
Or there you, if it's not what they're saying,
Yeah.
go argue whatever agreement you had in a different court. It was before you guys were married, years before, right? You had the car.
Yes.
Okay.
Your Honor, we're trying to avoid a situation here. I understand what the court is saying. But we have a situation where my client is continually put in a situation, all right? And the car is just another tool. She's being harassed and bullied. All right, this was their understanding, right, wrong, or indifferent, and she needs some sort of protection. That
She
the
could
only reason
file
they
in
stopped-
justice court for it. It's a separate property. These are the things that are fought over. It was a gift. No, it wasn't a gift. Yes, it was. No, it wasn't. All the time in justice court.
Well, we'd
I'm
like to
simply
not
not
have further
taking
litigation.
jurisdiction over it.
I was hoping that they could perhaps reach some sort of compromise.
Listen,
and work
and,
it
and
out.
under the statute, you're right. If they come to an agreement, I can add it in. If they don't, I'm simply not taking jurisdiction of it because it was not a community property item.
Well, that's why I asked for the mediation, because I think they had an agreement and understandings, and for whatever reason, it wasn't put in writing.
Okay.
Or or basically, she needs to be able to continue on with her life, just like Mr. Whitmore is.
You're right.
All
It's
right,
simply
and
not going to be
certain
done.
things
It's
need
simply
to
not
be
going to be done in this court.
Uh,
It's simply not going to be done in this court.
I
So
have numerous texts of her saying when she's gonna.
I'm
get
not
back.
dealing with the
Okay.
car. I'm
Okay.
not dealing with the car.
Okay, Your Honor.
So
So I don't know, Mr. Whitmore wants a continuance, but.
I don't know if we really need a continuance.
We can carry on all.
If the registration to school has been changed, the request was that I'm guessing he's going to die. You can never, you and your fiance can never leave the child home alone.
And that never happened either.
Okay. If it does, I would suspect that the plaintiff would call Child Protective Services,
Yeah, I
or at
would
least
expect the same.
make a report. Your fiance is not to grill the minor child. Do you understand that?
I've never seen that happen, honest.
So, again, we're back to, are you okay with the receiving party where you pick up the child for exchanges in Mesquite and she picks up the child from you?
We had an agreement of her doing all the commuting when she moved, because she wanted to move to Mesquite, and I said, that's fine as long as it don't interfere with my time, because I pick her up at 3:30, but I don't get home from work till 3:30, so I have to drive an hour there and back to get her, you know. She said she would do all the commuting to and from school.
How
and
long
to
has that
me.
been, how long has that been going on for?
Well, she did all the commuting until we met, and we come to some sort of agreement, and then that's when she's.
How long has she been commuting from Mesquite to do the trap for the,
I personally have been going back and forth about 2 months now.
so you have been doing that?
Yeah.
Well, there you go.
But she's lived there
It's
for probably.
burdensome, Your Honor. My
6.
client's working, she needs another job, she's having another baby, I mean, for her, and now she may not have a car, so there it is.
She can have a car, she just gotta do it in a different court.
I would like a third party pickup and drop off place for, you know, to make everything easier on us.
The easiest way, and I'm very familiar with, obviously, since that area, is simply to have the receiving party pick up, okay?
Okay.
There's no middle place, all right? The
Yeah.
Sloan exit's nowhere near halfway,
Exactly.
and there's really nothing all the way till you get to Mesquite. There
Okay.
really isn't. So,
That's fine with me.
okay.
I'm okay
So we'll
with
just have receiving party pick up.
Okay.
And the child needs privacy when the mother calls. She
I-
shouldn't be on speakerphone and she shouldn't be interrupted during the course of the conversation.
I could say something about that if I may. She prefers, my daughter Brendan prefers to have a speaker because she's usually just doing stuff, coloring, playing.
Then close the door and leave her in her room.
We leave her in her room, but
Okay.
she'll hit mute with her ear and stuff and hang up on accident if she has it on her ear, so she puts it on herself. We don't make her do that in any way.
She's not on speaker
I don't
when
care
he
to listen.
calls.
So let me set the tone here, because
Okay.
these parties truly, and if they lived in Vegas, I'd make them do the cooperative parenting course. I absolutely would. They've already done the COPE class. Clearly, there's still cooperative parenting issues. And if I made them go, they'd either have to travel once a week to Vegas to attend that for 8 weeks, or they'd have to pay probably someone in Mesquite $1,500 to $2,000 to go to that course. I don't want to order that at this point. I am going to order, let's do the Our Family Wizard thing though. I'm going to order that you both enroll and use the Our Family Wizard program. I do not want your fiance to be the one typing the messages. So at least have a record of communication back and forth when you guys are having problems, and if you come back, then we'll see to what level of cooperation there is. But it's a bunch of cooperative parenting stuff. You know, you need to learn to get along. It's going to be a long. She's only 4.
Yeah.
But let me. Point being, and I got this from the high conflict parenting coordinators. These people see this child enough that if we're going to have phone problems, we simply cut the phone out, both sides.
That would be
We simply do.
awesome.
Well, my client,
Listen, the point is, take what she can get. If she doesn't like the situation, I'll simply negate the whole, and he won't get phone time either. They both see the child, what, twice a week?
Yeah.
well,
It's a
she's
4-year-old
young
child,
She's 4 years
okay?
old, she
A
needs
4-year-old
phone.
child probably does like the phone on speakerphone.
Well, she doesn't talk on speakerphone when they call at the mother's
Listen,
house.
that's all I'm gonna change for right now.
Okay, I
They
appreciate
keep the
that.
child in the room, they can have, child turns on speakerphone, that's gonna be on the child. You guys don't have FaceTime, it's not a FaceTime thing?
Okay, Your Honor. So, I don't, are we continuing or are we
I-
going forward as is and the car is a non-issue at this point before Your Honor? And we can decide whether we pursue it.
Yeah, you have every right to pursue it. It's just simply,
I was hoping that perhaps if they got with a third-party mediator, they
Maybe
could
they
reach some
can.
sort of compromise.
maybe they can. I'm not gonna order them to that because, again, I'm not taking jurisdiction over the issue. She's offering for you to go to a mediator, try to work it out.
We've tried personally multiple times. Me and her sat down and
That's not a mediator. That's
Yeah.
what they need, a third-party mediator. Okay?
I feel the car's mine, and I've been trying to get
Listen,
it back for
you
over
can,
a year.
I'm not,
Yeah, I
simply
know.
throwing that out
So I
there,
don't know.
throwing that out to try to get it resolved.
Whatever you think would be best, I don't know.
Working it out would be the best, but if
Oh,
you
I-
can't work it out, then they're gonna have to file in justice court.
Definitely.
Thank you, Your Honor.
All right,
Thank you.
have a good day.